Hey guys, it's Steven with Foxtrot Family Law. We are talking laws and drinking claws. I've got our guest, Senior Associate with Foxtrot Family Law, SREE RAVI, with us today. I mentioned to you ahead of time that, I come from like a staunch child custody background where like 99% of my cases, it was kids involved. When we did divorces, it was custody through divorce. The focus was the kids. And so when you joined our team at Foxtrot last year, you had, I think, correct me if I'm wrong, a sort of a broader background, I guess, with what I call more traditional divorces where a lot of financial issues are involved. Is that right?
Yeah, that's right. Do a lot of forensic accounting, finding out where money is, where it's going, trying to just figure out how to distribute it, what are their best options, basically for division of estates at that point.
Okay, so when you throw out the term estate, help me understand, because when I just hear the term estate, if I'm just walking around, I think dead person. That's not what you're talking about, obviously.
No, I'm just talking about all the marital assets subject to division. So basically all of their assets and debts, everything that needs to be distributed one way or the other.
So one thing that might be helpful for folks to understand, like when a person dies, if that's something we're familiar with, that's a decedent's estate. And then
Right.
if two people are married, there is a marital estate.
Yeah.
Okay. Typically folks with child custody issues tend to be a little bit younger, and maybe there's not really even enough property to worry about except for the kids. Obviously, as kids get older and people accumulate assets, we have to have sort of hybrid cases. When a case really just focuses on the financial side of things, what would you say is like the biggest issue that people get into a tussle about, legally speaking?
Well, when it comes to division of existing assets, one of the harder parts is trying to determine what is there and what isn't. A lot of people try to hide things if they can get away with it. Division of retirement, normally you'd think it'd just be easy to do 50-50, but then you have to look into how much was actually earned during the marriage. And we get into more complicated things like military pensions, what part of their military career was during the marriage, what part was after. So we're starting to deal with things called marital fractions as to what was actually earned during the marriage. But the more, I guess, subjective issue is alimony, because we're looking at not just assets, we're looking at an ability to earn income, and we're looking at future income and unknown. And we're also trying to figure out we're trying to predict the future, basically. What are their expected expenses in the future? And how do we meet the definition of alimony, which is to maintain the status of life enjoyed during their marriage, when quite frankly, in most cases, that's impossible, because once you separate, you both have expenses that are probably going to be combined higher than they were when they were together. So it's and again, there's no set law, there's no equation for alimony. We just go into court and make an argument, say these are expenses, this is what this person's able to earn, what they've been earning. And we try to convince the judge to get as much as we can, or in the opposite, I try to convince the judge to award as little as he can, depending on who I'm representing at that point.
I have two questions about that, SREE. One, when people are walking around the streets and they just toss out the term alimony, are there different kinds of alimony? And if so, help us understand that.
There's alimony in gross and periodic alimony. The distinctions don't matter as much as they used to, because it used to be the main distinction was that alimony in gross was not taxed. It was just a division of assets existing at that time. And technically that's still true. But with periodic alimony, it used to be considered income to the spouse receiving it. And then the person who was paying it got to deduct it from their income when paying taxes. And that's no longer the case. Now it comes out of whoever's paying it still has to pay taxes on it, and the recipient no longer has to pay taxes on it. So that's also, had a negative impact in terms of how big an alimony award is going to be in the future. But the tax implications have made some differences there. But alimony in gross, like I said, is division of assets existing at the time of the divorce. So you're looking at what already is present, whereas periodic alimony is a division of a future income. So with periodic alimony, since you're dealing with something that's going to happen in the future, you can come back to court and get it modified if things change. Change of circumstances can happen. You may think he's going to earn $15,000 a month for the next 10 years, but 5 years down the road, gets laid off, gets injured, no longer making that money. You have to come back to court and modify that. Whereas alimony in gross is non-modifiable. Once it's done, signed, it's considered to be a division of an asset, which is non-modifiable by the court in the future.
Do lawyers who do what you do on the financial side of family law, do they have to be careful designating something as alimony in gross when maybe it's periodic, or is it pretty clear cut as far as which is which?
It's pretty clear cut, but you have to have the descriptor in your language. The order has to say that it's alimony in gross or that it's periodic alimony. And the different types of alimony are basically, we decide which one we want based on what we think is best for our client. That's what we try to go for. So, and for instance, like I said, periodic alimony can be modified down the road if the income goes up or income goes down. So if I'm representing a client that's receiving alimony, and I think there's a greater chance of the opposing party's income going down over time, I would be more inclined to request that it be designated as alimony in gross, even if it's paid at a certain amount every month for a certain number of months. The drawback to that, again, one of the differences between the types of alimony is that periodic alimony is essentially, or can be, indefinite. It can be until the person receiving it remarries or cohabitates with a member who they're romantically involved with, or passes away, right? Typically, that doesn't happen except for in very rare cases. But periodic alimony can also just be for a set number of months. So if we've agreed to 3 years of alimony, but I'm concerned that the other party is going to lose income, I'll request that it be set as alimony in gross. Therefore, they can't come back and modify it saying, well, I've lost my source of income. I can no longer afford to pay this much per month, and try to get it decreased. Of course, if their income goes up, we can't go back and ask for our alimony to be increased. So it's really just a situation where you have to determine what's going to be best for your client based on the current situation.
2 follow-up questions there. And then we might change gears onto something else. Does fault for the divorce come into play alimony wise? I mean, I heard you say that we're trying to allow both people to enjoy as much as possible the lifestyle that the parties had before the divorce. But if somebody has some surrogate family, like in Las Vegas or something, and they've been living a double life, living a lie, or God forbid there's domestic violence involved or something, can that affect alimony to a significant extent?
Yeah, I mean, Alabama is what we call a fault-based system. That means whoever's more at fault is going to be receiving less. So it can be a huge factor in determining whether or not the other party is entitled to alimony. As to whether or not the number changes based on the other party having, the surrogate family or affair or whatever caused the divorce, that isn't quite as serious because the numbers are still the numbers. The income is still the income. The recipient's expenses are still their expenses. The likelihood of them getting alimony, though, is what's going to be altered by the actions of the party who's more at fault. So there's, typically speaking, you're looking at simply the expenses versus the income and try to find the middle ground. And in worst case scenarios for the person paying the alimony, you're looking at like around 30 to 33% of their take home being an award of alimony to the other parent. That's, a worst case scenario for the person paying the alimony.
Okay.
And that's, still very unlikely, because they're just still trying to balance out what the numbers are versus, when it comes to fault, they can only do so much. They can't necessarily.
Yeah, we toss around the term windfall or jackpot justice. I mean, that's not what we're talking about, is what you're saying.
Right. But fault for the divorce can definitely have an impact on whether or not the other person gets alimony.
One follow-up on that. When people come in and they come to you and they say, hey, I want to hire Foxtrot, I want to work with Mr. Ravi and really figure out financially what we need to do with this divorce. I mean, you see billboards and, advertisements online for like $1,500 uncontested divorces, like where you just drop the agreement and it's done. But everything you're talking about, it sounds like even just drawing up the agreement on something like this is going to be a significant process and significant commitment.
Definitely. It's a contract like any other contract. You have to, the value of it is in the details. We try to have a contract that is going to ensure that the parties don't end up back in court litigating something. We want to make sure everything is covered. We want to make sure both parties fully understand what they're agreeing to. And of course, I want to provide the best language to protect my client when I'm drafting it, in a way that prevents the other party from going back and attacking it in court later as well. So there's a lot of details that go on in divorce. You can have a very simple piece of paper, but in the end, if it doesn't cover the right details, those people are going to end up back in court spending more money, because now they've realized that something wasn't taken care of and they can't agree on it. So they just have to go to a judge and litigate it. Got it.
Well, that's SREE RAVI with Foxtrot Family Law. That is a primer on family laws with some white claws interspersed in. And just for the record, White Claw has provided no remunerary or pecuniary interest in this, but thank you for that info. What is that?
I was going to say, this particular situation, the white claws, no laws proverb stands up.
There are in fact laws and there are white claws, but yes. But it's difficult to tell. But got it. Well, Mr. Ravi, that's really helpful. And it sounds like you've been able to help a lot of folks through a very difficult time in their life. So thank you for that.